My name is Kelly Amram, and today Brian and I will be discussing with our client what the phrase en banc means. En banc is a French phrase which means on the bench. It usually refers to a court of appeals in regards to a decision that has been reached by all current judges of the court. The U.S. Supreme Court and other state Supreme Courts always hear their decisions en banc. In the U.S. Court of Appeals and some state court of appeals, cases are randomly assigned to a panel of judges. These judges then hear a case, grant a decision, and provide written explanations of their opinion. Once the panel reaches a decision and issues their opinion, each party, either the appellant or the appellee, has the right to request a hearing en banc. This allows for the case to be heard once more, but with all of the court's judges present, not just a select few from the panel. Some cases require that the request for the hearing en banc must be made before the other party takes the case to the state Supreme Court. This gives the parties the ability to choose whether they want a rehearing en banc or if they want the cases to appeal to a higher court. I'm now going to let Brian explain the rest of what en banc means. Thank you for your time.
Hello everyone, my name is Brian O'Keefe. I'm going to be picking up where my colleague Kelly left off, and I'll be telling you all a little bit more about what an en banc hearing looks like. So not all requests for a hearing en banc are granted by the court. Often an appeals court will only grant an en banc hearing if the legal question in the case is one of significant importance, if the court itself or other courts in the country have not heard that issue before, or if the panel of judges' original opinion contradicts with either state or federal law or even precedent. An appeals court can also only overturn the panel court's decision if they are sitting en banc. In the federal courts, the parties can ask the U.S. Supreme Court to hear their case, but only if their case was heard en banc by the appeals court or if the appeals court rejected their en banc request. Appeals courts who do hear a case en banc will usually issue a separate opinion different from the original panel's opinion, a written opinion for that matter. The dissenting and concurring judges in that case are also welcome to write their own opinions, but the majority rule will control the case in an en banc hearing. Some U.S. courts of appeals have too many judges that they don't actually need all of the judges to be sitting on the court for it to be an en banc hearing. For example, the U.S. Court of Appeals for the Ninth Circuit, they have 29 active judges. Only 11 of those judges need to sit on the court in order for it to qualify as an en banc hearing. Thank you for listening to us. We hope this gave you a little more insight into what an en banc hearing actually is.